English Senior Newspeed. Mr. Chairman, Sir, I understand during the early years after our independence, the under trial prisoners constituted only one third of the total prisoners in jails. This situation prevails despite amendments in Criminal Procedure Code prescribing for release of under trial prisoners on personnel bond who have spent half of their maximum sentence. I would urge the state governments and chief justices of the high courts to take appropriate steps to ensure that this provision is implemented expeditiously. The e-court integrated mission mode project was launched with the objective of improving access to justice with the help of technology. Pace of the e-court project witnessed significant results which inter alia include ICT infrastructure upgradation of subordinate courts, launch of national e-court portal and constitution of process re-engineering committees by the high courts. Base 2 currently in progress aims at setting up of centralized filing centers, digitization of documents, adoption of document management systems, creation of e-filing and e-payment gateways. However, there is lack of awareness about the potential of e-courts project among the judges as well as public at large. I would urge upon Chief Justices of the High Courts to not only sensitive the members of the judiciary to utilize full potential of technological advancements being made, but at the same time disseminate necessary information about litigant friendly services being provided under the project to public at large. At present, the National Judicial Data CRIT provides summary of pending and disposed cases at the district and subordinate court level. However, in addition, periodic reports on the courts in a format that allows for the assessment of judicial productivity and congestion rates must also be published. Categorization and assignment of cases through case management system will help to ensure that the old matters are disposed on priority basis. Grouping of cases need to be undertaken as ongoing continuous exercise so that cases arising out of the same subject matter and involving the same question of law can be assigned to one large judge. Improved categorization will enable courts to adhere to pre-decided timelines. In this record, rules of high courts could be suitably amended to incorporate these mechanisms. Although several important and innovative initiatives are in place to improve upon the existing courts processes, yet there is significant room for further work is in this record. The high courts must take a strong leadership role in actively promoting a shift towards higher efficiency in the implementation of the project. Further research in the area of process simplification should also be encouraged to assess if the litigants are benefiting from various initiatives and to assess what else could be done. ICT initiatives is successfully completed will ease the day-to-day management of courts processes and provide necessary tools to the higher judiciary for performance appraisal of subordinate courts. The bar in India plays an important role in our judicial process, including alternative dispute resolution mechanisms. We must continuously engage with the bar for improving their standards and practices, as also for upgrading their professional skills through continued legal education. In this record, I must appreciate the efforts of Bar Council of India in establishing first lawyers academy at Kochi in Kerala. I hope other states would also facilitate their respective state bar council in such an endeavor. Sir, it is also necessary that adequate facilities are provided for the members of the bar while designing the infrastructure for the courts. The Bar Council has also expressed keen keeping in mind the critical importance of corporation from bar interesting in taking higher responsibilities under legal aid programs. I would urge upon the state governments and the high courts to actively engage the members of the state bar councils and bar associations in enlisting their support for the various programs and initiative towards reduction of pendency in courts. The exercise of policy formulation on judicial reforms by the government as well as judiciary needs proper analysis and research based on reliable judicial statistics. With the computerization of the high courts and district and subordinate courts, it has now become possible for the high courts to disseminate necessary information on the functioning of justice delivery system. The government on its part has formulated a scheme on action, research and judicial reforms encouraging law schools, judicial academies and management technical institutions to take up research project to assess the effectiveness of judicial reform measures and assess the feasibility of introducing new reforms. Yours faithfully.